Hey, I'm firearms attorney Gilbert Ambler, and today I want to talk about the ways that the ATF is trying to intimidate sellers of gun parts into not selling firearm parts. But before we dive into that, if you have not yet hit subscribe, go ahead, hit subscribe, like this content, share this content on other social media platforms, comment. That way you and your friends can keep getting this pro-Second Amendment related content. Now, what we're talking about involves the ATF's final rule on frames or receivers. Now, I'm sure most of you are familiar with this final rule, but we're going to go through a quick refresher just in case you're not up to date on the latest goings on with the final rule on frames or receivers. And what I'm talking about here all centers around the legal definition of a firearm, because federal law at 18 U.S.C. 921 defines a firearm and includes the weapon or the frame or receiver of such weapon. Now, ATF in August of 2022 issued a new final rule reinterpreting this definition to add in the term a frame or receiver that is readily convertible or readily restorable to operate as a frame or receiver. And in doing so, they shifted the legal definition of a firearm, because it used to be the question was it a frame or receiver? And if it had not yet been finished, it was not a frame or receiver and therefore not a firearm. By adding this term readily restorable before frame or receiver, ATF now says that even an unfinished frame or receiver that can be readily converted into a functional frame or receiver is now also included within the definition of a firearm and therefore subject to the Gun Control Act. Now, we of course think this was an unlawful interpretation, and it appears that so do some courts, because there have been multiple lawsuits challenging this, including Polymer 80 v. Garland, including the Vanderstock case, and including Morehouse Enterprises versus ATF, and we're starting to see the fruits of these lawsuits. As recently as a couple of weeks ago, an injunction was issued in the Polymer 80 case enjoining the ATF from enforcing this rule against Polymer 80. But other than those who it has been enjoined against, the rule is still in effect to everyone else. And what this rule says is that if it is an unfinished frame or receiver, but the ATF thinks it's readily convertible, they consider it a firearm. So how does the ATF determine whether it's readily convertible? Well, they say they look at things like the time, the attention, whether there are guides sold with the firearm, whether there are additional tools, whether there are jigs, whether there are molds. These are all things that the ATF considers when determining whether an unfinished frame or receiver, a chunk of plastic or a chunk of metal, is actually a firearm subject to the Gun Control Act. Well, it appears that the injunctions and all the legal attention that this final rule has been getting has not slowed the ATF down one bit, because they seem to be doubling down. On March 21st, they issued a public safety advisory, essentially a notice, warning the public that if they learn that someone is structuring sales or structuring businesses to avoid the Gun Control Act, that they would consider it a willful violation. Now, that term, a willful violation, is important, because what that means is it means that the ATF would come after somebody criminally if they find a willful violation, okay? Or at least has the possibility of coming after them criminally. And so what they are doing is they're saying, even if you sell an unfinished frame or receiver that has not yet met the definition of a firearm, if you separately provide access for someone to buy the tools, the equipment, or even just to get the instructions on how to finish that frame or receiver, we are going to consider it that you sold a completed firearm, because we're going to consider that a readily convertible frame or receiver, therefore subject to the Gun Control Act. And so what they're saying is, even if you're selling that frame or receiver alone without anything else, if you're providing links to where other people can find the equipment or the tools or the instructions, or even if you happen to own another business that sells tools that could be used to finish the firearm, ATF is going to accuse you of having tried to circumvent the Gun Control Act. And this is tremendous, because think of how broad this is. Think of the tools that you would use to finish an unfinished frame or receiver. I mean, we're talking about things like sandpaper. So if you own a business where you sold a couple unfinished frames or receivers, and you also happen to own a hardware store, the ATF is potentially going to accuse you of a willful violation of the Gun Control Act. I know it sounds ridiculous, but I think we all understand what is really going on here. I think the ATF is trying to intimidate people from selling parts and firearms parts and kits and tools that could be used even as they're losing in the courts. And it gets even worse because ATF in this public safety notice asks people to tattle, to call up their local field office if they know of anybody selling such equipment, selling such tools. They say, go ahead, tell us because we will prosecute those individuals for conspiracy. If you are concerned about this, I think you're absolutely right. To me, this appears to be the actions of a rogue agency because this agency should be concerned whether their rule is unlawful because it looks like some courts are starting to say this rule will not stand, and yet meanwhile they are doubling down trying to threaten people. If you enjoyed this content, go ahead, hit that subscribe button if you have not already done so, hit that like button, go ahead, tell your friends. Until next time.